Everyone. Welcome back to Professional Development for Creative Practices. This is the second part of Unit 3, which is legal agreements. This is going to be where last class we talked about the standards for legal agreements and what common elements we find in contracts. Essentially, we tried to talk about what were the basics and what were the kind of the main things you need to know about contracts. But what we mostly focused on was how do we construct contracts and what are they as a thing. What we haven't talked about yet is who makes the contracts fair. Oh man, this is the second time I've had to record this lecture because of technical problems. We're gonna take a breath, take a second to reframe. Okay. So what I was trying to say is last week, what we talked about was how do we construct a contract? But what we haven't covered is kind of the fairness aspect of it. So how do we make a contract fair so it represents both parties well? But then what happens if one party doesn't abide by the contract? What happens then? So it's kind of the more an element of what the second part of the unit is on. And what we're going to talk about today is we're going to split into two big categories. We're going to talk about negotiation, and we're going to talk about breach enforcement and defense. Basically, what have contracts go wrong? So the first part, negotiation, is going to be more focused on what is the process through which we can make contracts more fair. And that comes in the negotiating of the agreement. And the second part is how do we handle things when the contract doesn't work out? What are our next steps? So let me just take a second to switch over to the teaching site. We've got a little bit of a green screen issue there, but I'm going to boo, 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 boo. Do, 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 do. And fixed. Oh, don't need to see my face. So we're going to start off with section 3, the negotiation process. So it's all on the same page with legal agreements. Here's everything we went over last week. Okay, and here we are. So let's talk about the negotiation process. Now, this is probably the thing that I when I hear this from students, it's usually in terms of they have to negotiate a job offer or they have to negotiate a pay rate. And I think across the board, what everyone says, and what I feel too, is that negotiation is an incredibly uncomfortable process because it's essentially arguing. And I'm not a very argumentative person, but to be good at negotiation, you kind of have to take it out of that context of kind of like what the GIF is doing here. It's not so much like people sitting across the table all the time doing like offer, counter offer, and yelling and screaming and scratching and hair pulling and all that stuff. Negotiation is very much about fairness. How do we make things more fair? How can we maximize our value, but also preserve the relationship and kind of come to a common understanding? So let's jump into this process. Negotiation is actually one of my favorite things to think about and learn about. Okay, so what is negotiation? Negotiation it's a process for settling differences. Not so much like settling arguments, like you and I are angry at each other, let's sit down and negotiate. It means that you want one thing, I want another thing, and we have to settle that. We have to find a compromise and agreement, which is the second bullet. And then here's the big thing, it's a way to avoid argument and dispute. A lot of people think the negotiation itself is argument and dispute, but there's actually a way to avoid argument and dispute. And what negotiation is not about winning at all costs. It's a really common misconception. It's not about stonewalling the other person so you can get as much as possible out of them, so you can get the perfect deal, the perfect thing. That's not what negotiation about. A negotiation is about settling differences, compromising agreement, and avoiding dispute. If you try to win at all costs, all you're going to do is burn bridges, and people will not want to work with you. You'll develop a reputation of stonewalling people, and then they're going to try and figure out ways around you. Blah, blah, blah. But so what are some negotiations you've all participated in? Nearly every day you participate in negotiation. If you want something from someone else, you participate in a negotiation. Some are simpler, some are more complicated. Sometimes it's as simple as walking into a shop and wanting a candy bar and asking how much it is. And the person says it, and then you say, okay. And that was a negotiation. It's just, you were both kind of like, it's what's printed on the sheet. But, go to, but then there's like the common example of, it's like the classic, what is it? The carpet salesman, so you go and the carpet salesman's like, oh, it's $100. And you're like, no, 10. And you're like, no, it's 100. And you're like, it's like 15. And you start to walk away and they grab you and they're just like, well, I don't know, maybe I can do 50. So that's like some of the things people think about when they think of negotiation. But the point is that you've been in hundreds of negotiations already, probably hundreds of negotiations just in the past month. So really try to tie it in back to skills that you already have and experiences you already have. So great negotiators, they understand that negotiation is a balance between two factors, which I've already kind of mentioned in the intro. We want to gain as much value as possible. We want to preserve the relationship with the other party. Now, why is that important? Why wouldn't you just want to gain the maximum value? You can gain the maximum value from someone, but then the thing is, if you really burn them, like you take all of the value and they don't get anything out of it, they feel cheated, or they feel taken advantage of, they're probably not with you again. And it's just not the best to do business. Because the thing is, if you preserve that relationship, but gain as much value as possible, they might have feel like you got the better of them this time, or maybe they're going to get you next time, but, or maybe there is no conflict. Maybe both parties are happy with the compromise. But the point is, you're going to develop more relationships over time, and that is going to benefit you in the long term. So remember, negotiation, we want the value, but we also want the relationship. So let's talk about the negotiation matrix. It's a good way to visualize negotiation. Oh, I'm just going on the wrong screen. So this is called the Lewicki and Hayem negotiation matrix. So let's just try to get this fully into screen. Okay. Here's the basic idea. You're going to see up on the x-axis, y-axis, I don't know. That axis, you're going to see our wants and needs, what we want to get out of a negotiation. And then on this bottom axis, you can see their wants and needs, what they want. And so what you get out of this matrix is, if it's so, okay, so let's say that this axis is me and this axis is you. Axis is you. I can't say axis for the life of me. Avoid as a strategy in negotiation. So it's like, I lose, you lose. So I'm like, I'm not budging on my price. And you're like, well, I'm not budging on my price. And we just sit there with our arms crossed and we just like, well, not doing it, not doing it. That's what's known as like an avoidance strategy. And the thing is, what happens? I get the least amount of value and you get the least amount of value. So I lose, you lose. So let's look up here where, we compete. So, I really push hard on the price. And I'm just like, and you're just like, okay. I just can't deal with you arguing with me anymore. And you're like, okay. And then like, I win. That's the competitive strategy. It's me trying to maximize as much value as possible. This is the dream of this first bullet point. Gaining as much value as possible. That's the competitive strategy. Now, down here, we have accommodate, which is you win, I lose. This is the extreme of the second point. maybe I just give you whatever you want because I want to make sure that you don't leave me and we do business again in the future. You know, I just completely bend to your whims. That's the accommodate. So as you can probably guess, you don't want compete or accommodate or avoid. Those just aren't good situations. Most likely, most of the time, if you're a very skilled negotiator, or not if you're a skilled negotiator, so you do like, if you're basically good at negotiation, you're going to fall somewhere in the realm of compromise. I win some, I lose some. You lose some, I win some. It's a nice compromise. We have to give up a little to get more. Now, the super golden, awesome rainbow unicorn fantasy is to get to this one, collaborate. It's where you stop seeing the person you're negotiating with as a competitor and start to see them as a collaborator. How can we work together to maximize value for both of us? It takes a lot of teamwork. It takes a lot of open questions. It takes a lot of honesty. Getting to that point, though, that's the point where you both win. This is the golden unicorn fantasy. This is the hard part of negotiation. But most of the time, we're going to end up in this area of compromise. Avoid competing, accommodating, and avoiding. Avoiding. Okay. So I've broken down negotiation into 5 steps. And I want you to notice that the 4th step is bargaining and problem solving, which is what people think is the entire process of negotiation. But negotiation, a good negotiation, it normally happens in 5 steps. So first, preparation and planning. Yeah. Preparation and planning. You want to be prepared before you walk into the negotiation. You want to gather information and cement your position. So the reason we're talking about this in legal agreements is that this applies to so many different things in creative practices, but we're really, really, really needed in negotiation. We need it in contracts because the negotiation is when you're going to cement everything. And this is kind of the deal that moves forward. It defines your working relationship. It defines how the business is going to work. I mean, it just locks everything in. So you really, really want to come out of a negotiation getting what you really want, but also preserving that really strong relationship. So the thing is, if it's so impactful that this negotiation goes well, and the outcome is so important, you would imagine that you do a lot of prep work before you walk in the door. So when I say gather information and cement your position, let's say you're applying for a job. Before you walk in there and negotiate for the salary, you should know, what do other people in this industry get paid for similar positions? Did you ask around? Did you see what your friends make? Did you go on Glassdoor and look up what the averages were? Did you compare and contrast? Do you have other offers on the table? Gather that information, see what you can find out. And you want to do that so you can cement your position. You want to be arguing from a really strong place so that you have a good, so that you're negotiating as equals. So it's a lot of work. The thing is, you want to know your Watna, your Bhatna, and your Zopa, which makes me sound like a crazy person. So this is stuff from the first place I really learned was I had a class in grad school on negotiation. It was actually a really fascinating class. And what I'm telling you right now is the very, very skim little bit of the iceberg in terms of what you can learn with negotiation. But that's where I learned these funny terms. It's Watna, Bhatna, and so let's start with Watna. What is a Watna? What is a Watna? A Watna is the first alternative to a negotiated agreement. Basically, if you can't come to an agreement, what's the worst case scenario? So it's just, you have to think about what happens if the negotiation fails. A lot of times it's like a negotiation can feel like life and death. I think you're like, well, wait a second. If the negotiation doesn't work out, I'm not going to die. So like, let's say that you're an artist and you need to secure a loan. You need to secure a loan of your work to a museum. What's the worst outcome to the negotiated agreement? If it doesn't work out, you're not going to be in the show in the museum. But it's not going to ruin your career. It's not going to damage the artwork. I mean, there's all these things. It's like, there's all these things that'll float around in your head and drive you nuts. We should have a very clear, very simple, What is the worst alternative if we can't come to an agreement? So then there's your BATNA. Now, BATNA is the best alternative to the negotiated agreement. This is another way to put this is, I like to use employment as this example. Let's say that you are being offered a job. It's a job you really want. Let's say that you are going to be an exhibitions assistant at a major metropolitan museum. You're just like, this is great. I'm really going to learn the ropes. It's going to be awesome. And while you're in that negotiation about what the salary should be, you also know that if this doesn't work out, there's another job. There are other jobs at other museums you can easily get, or maybe you even have an offer from another museum on the table, which is amazing because then you walk in there and you're like, you know what? If this doesn't work out, my best alternative is I go take the other job. And that gives you this sense of confidence, and it also lets you know, it gives you that position of power. It doesn't make you think that everything hinges on this single negotiation. It gives you an ability to say, well, I know I can walk away. This is like going back to the rug salesman. It's like, he's like, wow, he or she or whomever is like, here's this carpet, it's $50, take it or leave it. And then you look across the street and you're like, well, there's more rugs over there. And as you start to walk away, the person grabs you and is like, okay, maybe I can lower my price a little bit. That's like living out a BATNA. It's like, well, what's my best alternative? I'll go shop elsewhere. I'll go shop where they will take me seriously and lower the price. That's a BATNA. So BATNAs are a powerful tool. Now, ZOPA, besides being something you would probably yell in like a Greek restaurant, is the zone of potential agreement. And I made this little chart here, black background because I'm terrible. Here's your position. So we have your best case and we have your worst case. Money is an easy way to talk about this. I think I can do a whiteboard on here. Let me try this. No, not in this program. Okay, so over on the left, we have your best case. So let's go back to the exhibition assistant at the major metropolitan museum. Let's say that your best case scenario, your pie in the sky, golden unicorn rainbow fantasy is to make $90,000 a year. That's your best case. That's like if everything works in your favor, $90,000 a year. Now, what's your worst case? At what point would you just walk away? Let's say it's $30,000 a year. You're like, at $30,000 a year, I can't even make my rent. It's not worth it. Whatever. I'm turning down this job. So between your best case and your worst case is like $60,000. Now, when you walk into the room to start negotiating for your salary, what number are you going to throw out? It's a tough question. Any number you throw out is just going to move you. Like if you start at the classic advice is start high and have them work your way lower. So you don't want to underbid, but you think, well, they're not going to give me my best case. 90,000 is too much. I know they're just going to laugh in my face. Maybe I'll start around 70. Well, you don't know. It's hard to guess. That's the point of the ZOPA. You have to think about what their position is. So their best case scenario is that you are the cheapest person. Their best case scenario is that you'll take a job for $28,000. Their worst case is $75,000. Anything above $75,000, they can't do it. But they don't want to pay you their worst case, just like you don't want to take $30,000 as your worst case. They don't want to pay you $75,000. So between your worst case and their worst case, you're somewhere between $30,000 and $75,000. That is your zone of potential agreement. So now, what's your starting bid? You figure they're not going to do 90. Let me say 80. So you say 80, and they're just like, oh my God, 80. No, that's way too much. And in their heads, they're thinking, 80, it's only $5,000 over or worst case, we can definitely talk them down. So then they throw out a number. They're like, okay, how about 40? You're like, 40? Oh, that's so low. They don't know that your worst case was 30. 40 sounds great, but well, if they said 40, that means they're still somewhere in the middle. I can work my way up. And you keep going back and forth, and maybe you end up, I mean, this is a pretty wild span. Salaries usually aren't our difference of like $30 or $40,000 when it's under 100,000. It's usually not that much of a sway, but this is just an example. But you keep going back and forth, and you work your way towards that ZOPA, and maybe the final thing is like 55. 55, it's a decent salary. You feel good about it. You got good benefits. They didn't hit their worst case. You didn't hit your worst case. You both kind of want out in this scenario. But that's what the zone of potential agreement is for. It's to know where you can possibly agree so that you know what the extremes are and you can work your way towards the middle. This is part of the preparation. Excuse me. So, and this is just the first stage of negotiation. The second stage is called setting the stage. Second stage, setting stage, whatever. You want to understand the parameters of negotiation. Who are the parties? Who are the negotiators? Where will this take place? Is there a time limit? And is there anything that's off limits? It's very much, you want to know the sandbox that you're playing in. These are things that you really want to establish ahead of time. Who are the parties? So like, let's say that you are a band and you're assigned a major recording contract with a huge distributor. And so in the room are a record producer, a company representative, and your band. Now, is this a three-way negotiation? Who's the record producer on the side of? Who does the record producer work for? If they work for the distributor, well, then you have to consider them one party that you're negotiating with. If they're not, they might not be key to the negotiation, and now you're just in a negotiation directly with the distributor. You need to know who the parties are, who are the negotiators, who are the deal makers. Where will this take place? It's good to know. It's just good to know where are you going to have the negotiation. It might be over the phone. What is the time limit? This is a tactic a lot of people will use. They'll come up with a fake time limit. Oh, you have to decide now. We don't have a lot of time. Well, clarify how much time there is. Can you come back to it? Is there a way to extend that deadline? It's a way to push you to make a decision. And then, is there anything that's off limits? When I was talking about the job example, it's like, could I get some benefits as part of this package? Could you increase my retirement package if I take a lower salary? Is there anything besides that main point that you're arguing about that can be brought in and be part of the conversation? Point 3, clarification. Clarify what you're negotiating. Are you negotiating salary? Are you negotiating employment? Like, it's good to just say, what are we trying to do? What are we need to agree on? What are our goals? And then also, what's the priority? And do you have common ground? Is there a thing that we both want as an outcome of this? This is the clarification step. This is when you start to ease towards collaborating with the other person. Before this, it's like setting the stage, know what you're going to argue about, like cementing your position, being ready, you're going in, you've got your boxing gloves on, you're ready to go. And then you start to clarify, well, what are we trying to get to today? What's our goal? What's the priority? Do you and I have a thing that we both want out of this? That's the clarification stage. 4, the fourth stage, this is the one that you're thinking of when you think of negotiations, where you say offer, counter offer, I'll give you this if you give me this. And like, can you bend on this? Can you do this? This is, you notice it is the second to last of the stages. Just do all this prep work beforehand. And then finally, closure and implementation. So once you've come to an agreement, you need to solidify those terms and make a plan for action. The worst thing, I've done this, I know a ton of people that do this. You go into this really complex negotiation with someone, neither of you write it down, and you're so tired and you just leave the room. And then 3 days later, you're like, wait, what did we agree to? What are we doing? And then you end up negotiating again because neither of you remember. So closure and implementation, when you've come to an agreement, solidify the terms, make a plan for action. All right, let's get into some tools of persuasion, which sounds like a really great 70s soul band. So very quickly, I just want to go over some tactics that people are going to use. This is going to come up in the workshop. There are tons of negotiation tactics. There's all kinds of different ways to play this. There's tons of really great books on how to be a good negotiator, but 20,000 foot view in this class from high up, let's just talk about 3 big ones. Perception and appearance. So to win in a negotiation, some people will use positions of authority to claim a higher ground, or they'll rely on the other party's perception to gain a higher ground. So this is where you're going to get, does arguing with a person that's older than you make you feel uncomfortable? Someone who's physically larger, someone that holds a much higher position, someone that has a really strong temper. I'm sorry, the temper is a bad example, but someone that is relying on this appearance, this false authority they may have, or real authority. It could be like they could be like the director of a gallery. It's like they have this authority, and if they're using that as their main argument, how do you work against that? But it's good to be aware of it. It's good to be aware that someone they might not have a good argument as to why. I'm talking around things. Let's go back to that museum example. You're going to be the exhibitions assistant, and they start relying on well, we're the most important museum in this regional area. And it's just like, well, is that really a factor in discussing what your salary is going to be? Whether or not they're a really important museum? No, we're talking about your employment, your job. Their status is unrelated to how much you're going to get paid. Emotion and attitude is the second tactic. This is when you ramp up other parties' emotions using tactics like anger, guilt, condescension, pity, and in some cases, just like straight up gaslighting. So this is where you really, this is where people do the yelling. This is where people tell you you're stupid. This is where people say, that's not how we normally do things. You're an outsider in this industry. What do you really know? And it's all a play. It's a tactic. It's just like the authority thing. They're trying to knock you off, put you off your game, make you feel stupid, make you acquiesce, because then they'll be able to take a higher position in the negotiation and push you towards what they want. So perception and appearance and emotion and attitude, those are 2 ways that a lot of people are going to negotiate. The third one, the one that I prefer and I think is most effective, is logic and reason. It's creating a sound argument based on a strong logical framework. So let's go back to this example of getting hired. So if you sit down and you say, okay, I know what the going rate is for this type of position at similar museums of similar sizes, and this is what I think I deserve. And then they say, well, that's twice what we can pay you. You're not from this industry. What do you really know? We're such an important museum. And you just look back at them and say, this is what other museums of similar sizes pay this position. So this is what is the competitive rate for this position. It's based in logic. It's based in reason. You're not being angry. You're not being stupid. It's not about your background. It's not about anything. It's the fact that you come in with logic and reason. Say it's an entry-level position. This is what other museums would pay. And this is what I think I deserve, given my exceptional background. And the fact that we're even at this stage where you're going to hire me. You obviously see something of value in me. So it's creating a logical argument. So when they push back and they're just like, we're such a big important museum, or that's an insulting offer, just keep going back to logic and reasoning. Because the truth of the matter is, if they're really dependent on perception and appearance and emotion and attitude, if they're depending on these 2, it means they don't have a strong logical argument. Okay, I'm going to take a quick break for myself, but to you, it'll seem like a blip. Okay, and I'm back. It was probably less than a half of a second for you, but I took a nice long break. Now we are on section 4. So at this point, we've talked about how do you form a legal agreement? What are the basic things we need to understand about contracts? And then what is the negotiation practice? How can we argue to make sure that things are fair? How can we make sure that we are gaining value but preserving relationships? Locking a set of promises into a good contract that allows us to proceed with the work, to proceed with the employment, to proceed with the loan, to proceed with the things that we need to do. So it's like, we're good, we're done, right? Well, what happens when the contract doesn't work out? So what we want to talk about is enforcement, breach, and defense. Excuse me. How is how does a contract even work? Like, how is it made so that it needs, how is it basically, how does it even work? Like, how does it literally make the other person do what they said in the contract? What happens if they don't do it? What happens if they don't abide by the agreement that you have? How do you enforce the terms of a contract? Breach is about what happens when you or the other party break the contract. What happens when it goes wrong? Whether it's your fault or not. What do you do when there's a breach of contract? What happens when the contract breaks? And then finally, defense. What are your defenses when someone says that you've breached a contract? How can you work against that? These are basically the responses that you have to make a contract work in daily operation. So let's just jump into it. So the first thing we should talk about is, how can a contract end? So, oh, you know what? I ran spell check and there's still this really embarrassing typo right here. Depsite. Anyway, Depsite are best efforts. Business relationships don't always work out. Knowing how to end a contract is just as important as knowing how to create one. So more than any other chapter, we're going to emphasize that speaking with more than any other part of legal agreements, I want to emphasize everything we're about to talk about, you should really speak with a legal professional as best practice. So there are 3 ways that a contract can end. It's the best case, the meh case, and the worst case. So the best case. Now this is if things go well, or if the contract is just for a set period of time, it naturally expires. So the best case, the best way that a contract can end is that it ends automatically once the duties of both parties have been fulfilled. To simplify this, think of a sales contract. You give me the artwork, I give you the money, and we're done. Contract is fulfilled. Let's think about this from a freelancer position. Let's say that you were doing some, let's say you're doing some carpentry for a friend. They hire you to do some carpentry. So you come in, you buy all the materials, you go, you build the thing. Your friend comes over, says, this looks great. You invoice them, they write you a check. You deposit the check in your bank account. You're done. Maybe it's for a set period of time. Maybe you have a 1-year agreement with an agent, and this agent's going to help you break into the Los Angeles art market. That's what they specialize in. And it's a 1-year contract. And at the end of the year, they didn't really do very much for you. Contract's over. It's no hard feelings. Maybe you just don't want to renew it. This is the best case scenario. This is what, honestly, the majority of your contracts will end this way. So let's talk about the meh case. So if things aren't going well, or if the contract is ongoing, it doesn't have a set termination date, how do we end a contract? Like, how do we stop? We don't want to do this anymore. How do we stop it? The first way is by agreement, which is both parties agree to end the contract early. And this needs to be done in writing. Don't do this verbally. It can just be like, let's say that, let's say that you and I have formed a partnership. We're part of an arts collective, and we're going to be building certain public sculptures. After like a month of working together, we realize we just do not get along, and we're just on different paths in life. Are we stuck in this partnership forever? And it's like, no, we both agree this isn't working out, and we decide to end our contract early. That's it. It's like, meh, it didn't work out. That's why it's the meh case. Another way is by frustration. Sometimes things will happen that prevent contracts from being completed, and it's out of your control. So, like for example, let's say there's an extreme weather event. There's a tornado. If a tornado rips through and destroys your studio, it's going to be kind of hard to deliver on that gallery show. Your studio is destroyed. It's a terrible, terrible tragedy. That's frustration. The gallery cannot expect to enforce their contract with you when, something you never thought would happen, like a tornado, came through and destroyed everything. So that's by frustration. It's nobody's fault. It really sucks. Again, it's And then there's convenience. So it's a party can quit at any time by notifying the other party. So this is not an automatic option. It has to be built into the clauses of a contract. For convenience, a good way to think about this is when you quit a job, that's for convenience. You say, all right, I quit, and you walk out the door. This is just in here because it's in contrast to ending a contract by agreement. It's where both parties agree to end the contract. For convenience, if there's a convenience clause where you can terminate early, then you're done. Either of you can terminate. Again, this should be in writing when you terminate. But these are and these are going to be very, very common in your artistic practices, in your creative practices when you're working with contracts. Sometimes things don't work out, or shit happens, or maybe you just want to let someone go. It's not really working out. These are the different ways you can end the contract. So now let's talk about the worst case, the third one, due to breach. If one party is not following the terms of the contract, the other party may sue for damages, i.e. money, or to terminate the contract to get out of their responsibilities. So obviously we're not really going to talk about the best case very much. We're mostly going to talk about the meh case and the worst case. Those are the important things for you to know about with this class. So let's talk about enforcing a contract. So here's the thing. Contracts can be tricky when it comes to enforcement. So remember, a contract is a set of promises that is easily understood by a third party. In the case of enforcing a contract, the third party is often a court of law. So there's a few things you need to consider when you're enforcing a contract, when you're trying to get someone to abide by the set of promises that you both agreed to. One thing is you need to know your jurisdiction. So where are you based, or where is the contracted business taking place? This has a major effect on how it's enforced. So you have to adhere to state and local laws when you enforce a contract. This is why the governing law clauses you see in contracts are so important. So it's things like, let's say you're working with a gallery in New York, but you're still based in Pittsburgh. Is your contract according to New York law or to Pennsylvania law? It's really important to know the difference, and that should be very clearly labeled in the contract. Even if you're not in different states, it's pretty common in contracts to say governing law is this state. So some factors, state laws, like I've already mentioned, statute of limitations. It's a set period in time in which you're able to bring legal action. So if you're enforcing a contract and you wait too long, the statute of limitations might expire. Let's say that someone violates a contract and you don't go after them for 2 years. Your state might say, hey, you know what? You had to do it within 2 years for this type of legal action. You're beyond the statute of limitations. And then, you know what? You're just out of luck. This is the reason, like, let's say that you get out of a lease of an apartment, and the landlord takes your entire security deposit, and you're just like, all right, whatever. Landlord's a jerk, fine. And you leave. 3 years later, that landlord comes back and says, you know what? I found this other thing you damaged. You owe me more money. More than likely, it's beyond the statute of limitations. They can't sue you 3 years later. Plus, there's other factors that come into that. But that's the idea of a statute of limitations. And again, these are all things that legal professionals can explain to you. And then there's statutes of fraud. Not quite what you think it means. Statutes of fraud is more about preventing fraud. So these statutes determine if a contract must be in writing and what level of evidence you need to prove the contract, which we talked about earlier in this unit. So we talk about marriage licenses when you purchase a property, when you execute a will. That's what I was talking about. You might need it notarized. It's going to have to be in writing. Maybe you have to submit like the marriage license, you have to submit it to the local municipality. These are things to be aware of. Okay, so let's talk about breach. When we consider breach, we consider a minor breach or a material breach. Basically, was it a little mistake or was it a huge mistake? So when someone breaches or breaks a contract, it's important to determine to what degree the contract was breached. I'm going to keep saying this. Legal counsel, legal advice is definitely needed in a lot of these cases. But minor breach. So also referred to as a partial breach, it is a breach of contract that is less severe than a material breach and gives the harmed party the right to sue for damages, but does not usually excuse them, I don't know why it's him, them from further performance. So what this basically means is if you fuck up a little bit, there might be a little bit of a penalty, but it doesn't mean the contract's over. You might still need to finish out the contract. So let's go back to the landlord example. Let's say that in your apartment, you damage the refrigerator and the landlord says, hey, you know what? You damaged it according to our lease. If you damage the appliances, you have to pay for the repair. That is like a minor breach, because what the outcome of that is, you're not going to get kicked out of the apartment. You're going to have to pay for the refrigerator to get fixed. So you violated an aspect of the contract. It's a minor breach, but it doesn't mean that you're going to lose your apartment or anything like that. You're not going to get, the lease won't be canceled. It's just a minor breach. It's fixable is essentially what the idea here is. Then there's material breach. Material breach is a substantial breach of contract, usually excusing the harmed party from further performance and giving them the right to sue for damages. This is the big one. This is the one where you can get into a lot of trouble, and you might end up owing someone some money. So minor breach, material breach, the contract has been breached. What do we do next? You don't automatically go into legal action. You don't automatically take them to court. There are options before you get to this step. Those options are arbitration, mediation, and settlement. So before we jump into a lawsuit, there are a couple of steps in between that you can turn to. These are steps that should absolutely be handled by lawyers. And I'm talking about like major breaches of contract. If you're in a disagreement with your landlord, you can handle this yourself. So take this with a grain of salt. Sometimes these steps are built into the contract itself as a required course of action. So we talked about arbitration clauses in the contract we looked at during the workshop. So arbitration. This course of action involves both parties agreeing to a third-party arbiter. This is outside of a court. This neutral arbiter has the authority to make a decision about how the dispute should be resolved. What's an example of an arbiter? A lawyer. You hire a lawyer and say, okay, we want you to be a neutral third party to help us come to an agreement with how we need to fix this. The fun part is when you have an arbiter, you and the other person have to abide by that arbiter's decision, because you both agreed that's how we're going to fix this. We're going to go through a third party arbiter. We're going to present all our evidence and we're going to see what they think. Whatever they think is how we're going to move forward. So you're putting your power into the hands of a third party, which again is why contracts, it's very important that they can be clearly understood by that third party. Second, mediation. So this course of action is bringing in a trained third party who will help both sides resolve the dispute. The key difference here is that a mediator does not have the authority to decide how the dispute is resolved. They are just a legally trained neutral helper. This is what it sounds like. You and your friend get into a fight. Maybe someone comes in to help mediate the fight. They say, okay, let's listen to each other. What's a possible way that we can come to an agreement? A mediator is there to help you get to a solution, but it doesn't mean that you have to abide by their decision the way that you do with an arbiter. And then finally, a settlement. A settlement is the resolution between disputing parties. Settlements are a contractual agreement on how to proceed. Sometimes settlements involve one party paying damages to the other. So let's say that you get into an argument with someone, it's a freelance contract, and there's a dispute over, the scope of work. And you're pissed because you're like, you really inflated the scope of work. This is beyond what I agreed to in this contract. This is way beyond what I should get, like what the money I'm getting paid to do. This is way beyond, I'm not getting paid enough money to do this. And the other person's like, well, this really needs to get done. And we're already like pretty far in. And so you come together and you go to an arbiter, or you work with a mediator. And basically what comes out of it is the settlement is that maybe it's that you agree to expand the scope of work, but they agree to pay you more. It's a simple settlement, does not need to be complicated, but that needs to be written down. That in and of itself is a contract. So this is also a thing you'll see with a lot of news stories where they'll say like, oh, they settled out of court. I mean, that's what it is. Maybe the person agreed to not bring more legal action if they get paid a lot of money. And so finally, we have legal action. So in short, someone takes you to court. 100% you need legal counsel if you're being taken to court. Doing otherwise will put you at risk. What are the consequences of a contract breach? We talked about how you can handle discussion and problem solving with it, but like what happens if you lose? So when one party breaches a contract, under US law, the other party is allowed to seek relief. Relief is also commonly referred to as a remedy, but an even better word that would be to use is consequences. So there are three types of consequences to breaching a contract. There are three types of remedies. The first one, damages. The most common remedy, damages refers to a type of payment one party receives as compensation for a contract breach. Three types, compensatory damages. This is to compensate for damages, injury, and other incurred loss. So this is what, what's another way to put this? This is where sometimes people will sue for lost profits. So it's like someone wrongfully accused your restaurant of having rats in the kitchen. And so a lot of people didn't come to your restaurant and you lost a lot of money and you sue that person for libel. And, you're suing them to get compensatory damages. You want to get back, what you lost. This is the best way to say this is compensatory damages is based in reality. When we get to punitive damages are legal recompense that a defendant found guilty of committing a wrong or offense is ordered to pay on top of compensatory damages. This is basically when a court, when a jury, when a judge decides that, hey, you know what? In addition to like the $1,000 of compensatory damages that you need to pay this person, we also think that you did enough wrong that we're going to punish you and say that you have to pay $20,000 on top of that. Punitive damages are crazy. There are limits put in place a lot of times, but you'll also see this a lot in news stories. Once you start paying attention to this stuff, you'll just be like, oh man, like the punitive damages, it's like they charged that corporation $8 million in punitive damages. That's on top of the compensatory damages. And then liquidated damages. A liquidated damages clause specifies a predetermined amount of money that must be paid as damages for failure to perform under a contract. So where liquidated damages are nice, this is kind of what we were talking about, and this comes up in the Mike Montero video, the idea of a termination fee. So maybe it's that, hey, if you terminate, you owe me this amount of money. It's like you owe me all the money like that I need to be paid up to this point in the contract. Say it's like 50%. But, on top of that, you're going to pay me an extra $2,000 as a termination fee, because you terminated early. And so why is it of interest to someone to not fight you and just pay that termination fee? Because it's a liquidated damage. Basically, they're like, okay, we're going to pay the $2,000. We're out of this. And then you're not going to sue us. And you're like, not going to sue you. It's part of the Contract, I'm only allowed to get liquidated damages. So this is a good tool to have in your contracts as well. So it's much easier to do this than to have to try and get compensatory or punitive damages. Basically, it's good to have fees. So this is just damages. What are the other types of remedy? Specific performance. So in addition to or in place of damages, a plaintiff can also seek specific performance. This is the court ordering the breaching party to perform a specific duty that was in the original contract. So let's say that this is basically like getting your shit back. It's, like say they were supposed to give you so many widgets and they wouldn't give you that many widgets. And the court's like, you have to give them the widgets. Or it's like, you have to give them back their intellectual property. Or it's like, you have to release this thing to them. It's not money, it's performance. They have to do something. And then the final remedy is cancellation and restitution. Pretty straightforward. Cancellation, the contract is considered void, relieves all parties of obligations. Restitution, the non-breaching party is put back in the position it was prior to the breach. An example of restitution is, let's say that you're doing carpentry work for your friend and you buy a bunch of wood, and then your friend is just like, I don't need this anymore. Well, the problem is you bought all this wood and you're not getting paid for it. Restitution, they have to pay you the money to get you back to the financial place that you were prior to the breach of contract. So finally, let's just wrap up with defense, and I'm just going to blow through this real quick. So when we find ourselves in breach of contract, we have to defend ourselves to the other party, to a third party arbiter, or in court. So the following list comes from Free Advice Law. These are common legal defenses to contract breaches. This is basically the arguments you make. So it's like there was a breach of contract. This is how you explain why it happened. Why was there a breach of contract? So the first one is mistake or unilateral mistake, basically mutual mistake. We both fucked up. It happened, and remember, this could be like we both fucked up and we've decided to end the contract by agreement. This gets a little confusing because by the time I get to defenses, we've already gone through all the scary stuff with damages and remedies. Think back to the thing where it's like, how can contracts end? Maybe it's by frustration, maybe it's by agreement. It's not always legal action. Or, maybe we need to go into mediation. So just keep that in mind. This is not all like you're sitting in court sweating because someone's going to sue you for $1 million. But two types of mistakes. Mutual mistake, we both made a mistake. Unilateral mistake, one party made the mistake. There is something fun about a unilateral mistake. So it's like if you and I are in a contractual relationship, I made the mistake and you knew about it but didn't do anything about it to correct me. You're just like, you let it slide, and then you decide to sue me later. A court may decide that the contract is not enforceable because you let me get away with it. It was your responsibility to point out the mistake. Duress or undue influence. We talked about this with invalidation. Essentially, you can't coerce someone into signing a contract, and it's deemed it's invalidated. You can't physically threaten someone, or you can't threaten to sue them if they won't sign the contract. And then undue influence is kind of the same as duress, but it's not as intense. This is like something like, let's say that your boss, it's like, I'm going to fire you unless you co-sign on my personal loan application. They're exerting their influence over you. They're dangling your job on the line and saying like, you have to do this. It doesn't be that like a personal loan. It can just be, the idea is if your boss is pressuring you into signing something, if someone's exerting their influence over you, that's undue influence. So duress is like a little bit more extreme. Undue influence is when someone's being an asshole. Unconscionability, this is a weird one. Basically, it's that when it's so grossly unfair to the other, a court is like, the other party should never sign this. It's just so ridiculous. I don't even have a good example of this, but it's just a weird one. It's one that a lawyer could definitely explain to you. Misrepresentation or fraud. So this is when one party grossly misrepresents a material part of a contract and the other party relied on that misrepresentation as part of the contract. So for example, one party promises the intellectual rights, property rights to an artwork in a sale, when it was later determined that party never had the ability to sell those rights in the first place, the contract hinged on those intellectual property rights. They misrepresented their ability to sell those property rights. So misrepresentation, that's a defense you can use. You can like, listen, I'm able to get out of this contract because what they promised they can't come through on. And this is why. And then fraud is when the misrepresentation happens on purpose. Impossibility or impracticality, this is back to the tornado. Tornado takes out your studio. You can't do anything about it. It's impossible to move forward. And then finally, frustration of purpose. This is a little bit like impossibility, but this is like the reason you had to enter the contract has changed. So the example I made up is, let's say instead of a tornado, your star record producer, the main reason the band signed with your recording company, dies suddenly and unexpectedly. So now the band has no real reason to work with you. They wanted to work with Rick Rubin. They didn't want to work with you. So they specifically wanted to work with that producer, and it was part of the agreement. They might be able to get out of the contract due to frustration of purpose. It's not the fault of either party that that person died. To your knowledge, they weren't murdered. But there's no point for the contract to keep going forward. So it's frustration of purpose, which is different. It's not impossible to make it. It's not like there was such a terrible thing that you couldn't possibly fulfill the contract, but it's just like the reason to be in the contract isn't there anymore. That's frustration of purpose. So that's it for legal agreements. I'm going to hit stop and upload this. I'll see you all in class. And next week, we're going to get into representation and labor, which will be a lot of fun. All right. Thanks, everyone.